Val, this is Erick Kaardal, as you know, and we're here for a conversation about the Mille Lacs Lake walleye case. Save Mille Lacs Sports Fishing and PERM and resort owners and individuals have brought a claim in the Minnesota Court of Appeals to throw out the fishing rules at Mille Lacs Lake. And it's a very important period for us to get together, Val, because we're going to be discussing the briefs that have been filed. So there's a blue brief that was filed by the sports fishermen and PERM, and then there's the red brief, which has been filed by the state of Minnesota. The state of Minnesota would be the Department of Natural Resources and the Attorney General's office. So in summary, to begin, we're disappointed. We're disappointed because Minnesota in 1998 adopted an amendment to preserve our hunting and fishing heritage. And in our opening brief, our arguments were just very simple. So I'll go to page 1 of the brief, the statement of legal issue, and I'll just read it. Whether a DNR adopted fishing rule is per se invalid when the adopted rule in supporting 18,700 page administrative record do not apply nor mention Minnesota's Preserve Hunting and Fishing Heritage constitutional provision, that's Minnesota Constitution Article 13, Section 12, and the related public trust doctrine. So our legal issue we presented was that the DNR's adopted rule and its rule-making process didn't even mention the constitutional amendment, so how could they have even considered preserving hunting and fishing heritage without mentioning it? I mean, that's common sense, that's ordinary language. That's what we do. We look at whether the agency's following the law. If the agency doesn't even mention the law, then we know the agency isn't applying the law. It's that simple. And so in our brief, that's what we argued. Now, you don't need to be a biologist to understand that the agency has to follow the law. In order to follow the law, it has to mention the law and consider it and apply it. And so you don't need any expertise to do that. Now, perhaps there's some legal expertise that would be required, but no more than understanding the Constitution's there and to read the constitutional amendment and then to read through the administrative record. That kind of legal expertise is within the reach of virtually everyone. And so that's what we do in Minnesota, is we make sure our agencies are adhering to the law. Now we'll go back in the blue brief, that's the sports fisherman brief, and we'll look how clear the arguments are that are made. For example, number 1 is the court should grant the petition for declaratory judgment because the DNR adopted a fishing rule without applying or referencing the Preserve Hunting and Fishing Heritage constitutional provision and the public trust doctrine. Well, think about that Preserve Hunting and Fishing Heritage constitutional amendment. It was addressed to only one agency, and that's the Department of Natural Resources. So the Department of Natural Resources would know that that amendment applies to it. It wasn't done for the Department of Human Services, Department of Transportation, anyone else. The only agency that governs over our wildlife, that is our fishing and hunting, is the Department of Natural Resources. They set the rules, they enforce them through conservation officers. That's also why it's important that they follow the law. And here it's a big law, it's a constitutional amendment. So then we state this at page 10, the standard of review for administrative misapplication of law and legal error is de novo. Well, what does that mean? That means that, well, when it comes to an agency not applying a law, that's not a matter of agency expertise. That's a matter the court can look at in the first instance. It's almost like the DNR lost its copy of the Minnesota Constitution over this 20-year period. And that isn't acceptable. And that's something that the courts are well acquainted with. That is, when does the law apply, when doesn't it apply? It's like the DNR is arguing that the Hunting and Fishing Preservation Amendment doesn't apply to it, when actually it is the only agency it applies to. On page 14, we argue any DNR hunting or fishing rule adopted without consideration of the Preserve Hunting and Fishing Heritage constitutional provision and the public trust doctrine is per se invalid, as is the rule here. So again, the DNR must, in every instance, when it adopts a hunting and fishing rule, must consider the preserve hunting and fishing heritage constitutional provision and the related public trust doctrine. That public trust doctrine means that the state of Minnesota has to preserve our natural resources with consideration of the public good. And what the constitutional amendment did was it made very clear that part of the public good was preserving our hunting and fishing heritage. And with a study, you can discern what our hunting and fishing heritage is. For example, on Mille Lacs, you could go to any public library and you'd find out that what we do on Mille Lacs is we fish. And what we fish is we fish walleye because it's been a fantastic walleye hatchery and place for walleye to grow for centuries. We argue very clearly also at page 18, there is no way for the court after the fact to fix the DNR's ignoring of the applicable laws and adopting the rule. There's case law on this. The DNR has to apply the law, the Hunting and Fishing Heritage Preservation Amendment, during the administrative process. It can't come back after the fact in the court process and say, oh, it was implicit, or we were thinking about it, sort of telepathically or something like that. No, it can't be that. They actually have to sit down at the table and say, look, what's our business here? And part of their business was to apply the Hunting and Fishing Heritage Preservation Amendment. And that's what it should be. And there are other contexts where that's the case. When a group gets together, a group of government agencies, there's always a purpose. And that purpose is laid out in statute. In fact, an agency action not rooted in statute or law is unauthorized. So an agency always has to be rooted in the law that it's trying to implement. And then we also see at page 19, the petitioners request a broad, not a narrow declaratory judgment against the DNR to ensure the DNR follows the preserve hunting and fishing heritage constitutional provision and public trust doctrine when adopting future hunting and fishing rules. So this case is not just about walleyes, it's not just about Mille Lacs Lake, it's about the state of Minnesota. After all, the hunters and fishermen got the amendment passed to preserve hunting and fishing heritage, and then the DNR is to implement it. You get the law passed, DNR implements it. That's the way the system has to work. Otherwise, if the DNR is doing whatever it wants, rather than preserving our hunting and fishing heritage, then the DNR is creating our heritage for us. And that's not what we wanted when we passed the amendment. We wanted the DNR to work for us to preserve our hunting and fishing heritage. And that's what's been decimated at Mille Lacs. So that's what we've lost. We've lost our walleye fishing heritage at Mille Lacs, and that's the DNR's fault because it hasn't applied the law. Now that is what I have just finished is the blue brief. That's our brief, and that's very constructive. That's very positive. Sure, we're criticizing the DNR for failing its mission, failing to follow the Constitution and violating the rule of law, but we're going to the court to redeem the system. When the state agency fails to follow the law, then the court is there to fix it. And that's redemptive. It's such a powerful thing. And we can be very proud of our state when a court holds a state agency accountable for violations of the law. It tells us, no, there is a check on agency power. And when the courts fulfill that, that's a gracious thing. Now, what's disappointing, Val, what's really disappointing is the red brief. Now, the red brief is from the state of Minnesota. That's the Department of Natural Resources brief. And we read it, and we were disappointed. And in the first instance, we find that even when they describe the statement of the legal issue, rather than addressing the core issue, which is in our blue brief, is what authority do you have to adopt these rules without reference to Minnesota's Hunting and Fishing Preservation Amendment? Well, their statement of legal issue on page 5 states whether the Minnesota Department of Natural Resources acted in an arbitrary and capricious manner in adopting an emergency rule concerning fishing on Mille Lacs for the 2014 fishing season. All of a sudden they want to narrow the case to just whether this emergency fishing rule is arbitrary and capricious, but the case is broad. As I said, the case is whether the Department of Natural Resources ever has the authority on any lake with respect to any fish or hunting issue ever has the authority to pass a rule without reference to Minnesota's hunting and fishing heritage preservation amendment. And our answer, of course, is no, it never has that authority. But the statement of the legal issue on page 5 of the red brief doesn't even get to that question. And so that's where the brief distracts the public from the real issue at hand. And so they want to say the standard is arbitrary and capricious. This is about the emergency rule on Mille Lacs 2014 fishing season. And we're saying, no, this may be about those things, but it's about the dispute is about a broader legal principle, is can you proceed in adopting hunting and fishing rules without referencing the people's hunting and fishing heritage and the amendment. Another thing going on in this statement of legal issue is that we're moving away from the legal standard. Remember, our argument is if you don't apply the law, your rule is legally unauthorized. Now, in their statement of legal issue, they want to say the standard is arbitrary and capricious. But even if the DNR has not acted arbitrarily and capriciously in violating the law, it still violated the law. So a criminal defendant can't go in and say, well, I violated the law, but I didn't do it arbitrarily and capriciously. Well, the criminal defendant's still guilty. It's no defense to a lack of legal authority that you didn't operate arbitrarily and capriciously. So then we move further into the red brief. And at page 12, we begin their arguments. And their first argument on the box is, the Preservation Amendment did not alter the broad discretion afforded the Department of Natural Resources to regulate hunting and fishing for the public good. My. So what the DNR is saying is we still have the same discretion after the Hunting and Fishing Heritage Preservation Amendment that we had before. I mean, that's absurd. It's so absurd for the DNR to say we have the same power after the amendment as we had before. I mean, the whole purpose of the amendment was to preserve things like walleye fishing on Mille Lacs. And we have an agency directed by the constitutional amendment to preserve things like that. What could be more important than Minnesota statewide than preserving walleye fishing on the crown jewel of Mille Lacs Lake? I mean, it is the best lake in Minnesota, and it's the best lake for walleye fishing. It's the walleye capital of the world. Minnesota's state fish. Minnesota catches and eats more walleyes than any other state. This is who we are. And the DNR wants to tell these resort owners, you've got to learn how to market northern pike and smallmouth bass. Well, it might be easier for them to manage northern pike and smallmouth bass, but what should be managed is the walleye population so that we have that for generations to come. The DNR is arguing that the Preservation Amendment did not alter the broad discretion afforded the Department of Natural Resources to regulate hunting and fishing for the public good. They're arguing that not only didn't it affect what they're doing, but it also allows them to do anything they want. And this is why in our blue brief, we mentioned the public trust doctrine, because this has been tried before, like in Mono case in California. Los Angeles wanted to use Lake Mono and take all the water out, but it was going to affect the ecological balance. And the city of Los Angeles said, well, it's our property, we can do what we want. And the California Supreme Court said, no, when it's public land, you owe a duty to the people of California. So you can't do whatever you want with your land. Similarly, the DNR does not have that kind of power to decide to do whatever it wants with respect to our natural resources here, our wildlife, the Mille Lacs walleye, other fish, other species that we hunt and so forth. So they don't have the broad discretion. They're obligated and have a fiduciary responsibility to manage the natural resources for our benefit. That's the public trust doctrine. That's been recognized in Minnesota since the 1940s. And then on top of that, this restriction that with respect to hunting and fishing, you are to preserve our hunting and fishing heritage. Those are restrictions. Now, they're saying, well, our focus on the public good can supersede preservation of hunting and fishing heritage, can supersede the public trust doctrine. No, these are restrictions. If a regular trustee of a trust were to argue that my powers supersede the trust agreement, I can give the beneficiaries' monies away, we would say that trustee has acted in violation of the fiduciary responsibilities. Here, the DNR, in its trust role for Mille Lacs Lake, the beneficiary is the public. And the DNR has, through its own fault, led to the demise of the walleye in Mille Lacs Lake. And that's in violation of its legal responsibilities, and so the DNR must respond. It's not negotiable. The constitutional amendment was passed to hold the DNR accountable when it violates our hunting and fishing heritage. So that particular point in the brief, in summary, is trying to eviscerate the legal effect of the Hunting and Fishing Heritage Preservation Amendment. So basically, the DNR is saying your constitutional amendment to preserve hunting and fishing heritage is invalid. It doesn't matter. So we're saying, no, your little rule, which wasn't adopted properly because you didn't refer to the Hunting and Fishing Heritage Amendment, is invalid. And the DNR comes back and says, no, your constitutional amendment, the amendment was adopted by all the people of Minnesota telling the DNR to preserve hunting and fishing heritage, that's invalid. So who's in charge? So if the people change the Constitution by amendment, directing the DNR to do something, then the DNR doesn't do it and the people sue because it's invalid, then the DNR comes back and said, no, the constitutional amendment's invalid. Well, who's in charge? Is the DNR running the state, or the people running the state by passing laws? And this is really the battle. In this case, it affects all Minnesotans. It particularly affects anyone who cares about preserving hunting and fishing heritage in any place, in the metro area, in outstate, northeast, northwest, southeast, southwest, central, all those areas, all those traditions, all those things you have can easily be upset. In fact, someone called me a couple weeks ago and said, we went through the same thing at Green Lake, which is a wonderful walleye lake. The DNR introduced, without invitation, muskies. And the muskies grew like weeds, and they took over the lake, and they didn't have any walleyes anymore. And there weren't enough muskie fishermen that were really interested. And so why is it that the DNR introduced the species and promoted it at the demise of the walleye, which everyone wanted? So there are other examples throughout Minnesota. The next argument in the red brief is on page 14. Here, they argue, as a state agency with expertise in fisheries, biology, and management, the DNR is entitled to deference in adoption of the emergency Mille Lacs Lakes rule, which should not be overturned unless it's found to be arbitrary and capricious. Well, again, we have that arbitrary and capricious. The rulemaking process isn't authorized unless they cite the applicable law. So it's done for that reason. But I think what's interesting is the claim of the DNR to have expertise in fisheries, biology, and management. Now, our blue brief did not challenge the expertise of the state agency in fisheries, biology, and management. We just acknowledged, and which cannot be denied, that the DNR's effort at Mille Lacs Lake has been catastrophic for the walleye. I mean, you couldn't have designed a worse plan for the Mille Lacs Lake walleye than the DNR did. I mean, this is 20 years of DNR punishing the walleye, and now we have none left. And it's the DNR's fault. Now, no one's going to dispute the catastrophic result of these policies of the DNR. And we're not even going to dispute that they're the experts. But the experts got it wrong. That's why we're injured. But the reason why the experts got it wrong is they didn't apply the right law in the first place. Because if the experts had understood in the first instance that the responsibility of the DNR was to preserve the walleye fishing heritage on Mille Lacs Lake, they would not have started where they did, they would have not done what they did in the middle, and we wouldn't be in the position we're in. All the DNR had to do to preserve walleyes on Mille Lacs Lake is to follow the Hunting and Fishing Preservation Amendment, and they would have said in the first instance, we're going to preserve walleye fishing. And they have all the resources and all the expertise to do that, but they lost their way by not following the law. They weren't on top of their fiduciary responsibilities to preserve the walleye fishing, and so they lost their way. They were thinking about other things. And as a result, now we have them marketing and telling us that we have to enjoy northern pike and smallmouth bass, when what our fishing heritage is walleye fishing on Mille Lacs. So there's this big disparity between their expertise and how they apply their expertise on Mille Lacs. In fact, maybe there was simply a confusion because they didn't follow the law. If they had followed the law, it would have led to them to the people's heritage of fishing walleyes on Mille Lacs. But apparently it must have had ambivalence towards the people's heritage, some sort of indifference, because by all, if you review it, it looks like they've been managing for northern pike and smallmouth bass. So the only way to reorient them is to turn the DNR back to the law and back to the people's heritage. And we have to do it now before that heritage changes, because no one's going to fish walleyes where there are none. And that's why the lawsuit was brought. Then the last point in their brief is page 17. The emergency Mille Lacs rule is well supported by evidence that serves the public good. Well, that wasn't even an argument in our brief. I mean, the point about the emergency Mille Lacs rule is it's like a Band-Aid on an open, gangrenous green wound. Your arm's falling off and you put a Band-Aid on it. And even in that case, they, as I understand it, they've withdrawn the night ban that was part of the rule. But the whole point of the lawsuit is simply to reorient the DNR, a reset, if you will, towards preserving the fishing heritage on Mille Lacs. It's a very simple lawsuit as laid out in the blue brief. But the red brief, takes the simple and complicates it, takes the clear and obfuscates it. It's not addressing the issue. The issue the state agency needs to address, this is the Department of Natural Resources, is it going to follow the law or not? When the people of Minnesota gather and provide direction to the state DNR, is it going to follow, or is it going to be indifferent, or is it going to outright violate it? And that's more important, actually, than anything we're doing, because the DNR has to be tamed. They can't just run with rules and routine, because that leads to mediocrity. And so we need, as a democratic input, we need people helping the DNR by attending meetings. We need people helping the DNR by writing them. We need people helping the DNR by providing constructive critiques, testifying at legislative hearings. We need people helping the DNR by filing appropriate lawsuits. And so this lawsuit is an opportunity for the DNR to reset the relationships on Mille Lacs Lake. So you have the Indian tribes involved, you have the sports fishermen, resort owners, other stakeholders, the tourism industry there, and you have the DNR. And the DNR has caused the demise of the walleye, which we all kind of hold as sacred. And so what next? Well, the DNR has to be reminded, because it caused the demise of the walleye, that all of the stakeholders consider the walleye sacred. And so we need to move forward to preserve the walleye together. And I think what happens in the end is that the sports fishermen will be reasonable and go with low possession limits or catch and release, and the Mille Lacs Indian tribe and the other tribes will pull out the nets during the spawn. It's just inevitable that has to happen. And if we do that, it'll be a victory of the people of all races, and it'll be a loss, but only a temporary loss, for the Department of Natural Resources. So although the Department of Natural Resources must take accountability for its actions, it should rejoice with the reset and the fact that it's lost in this case because the direction it was going was an error, and it was causing really a catastrophe for all those involved. So I want to thank you, Val, for your time today. And we have accomplished a lot in this lawsuit in a short period of time. And I hope that people have a chance to read the briefs, and we'll get out the date for the hearing as soon as possible. I hope everyone can attend.